graduate of the University of Virginia. He spent, well, must be about 35 years now, right, Mike, studying Lincoln and the assassination. He is most notably the author of American Brutus, the book that's for sale, published by Random House in hardback in 2004. To write the book, he actually devised a new database program that enabled him to organize and sort historical data by hundreds of different criteria. In his review of the book in the Washington Post, Jonathan Yardley said, and I quote, "His most impressive accomplishment is not the computer-generated timeline he's able to construct, impressive though that most assuredly is, but his depiction and analysis of Booth himself." And Yardley concluded by saying that Michael appears to know the subject, the Lincoln assassination, better than anyone else now alive. So with that, I will give you our speaker tonight, Michael Kaufman, will be talking about the assassination trial.
Oh, thank you. Well, thank you very much. And thank you, Jonathan Yardley. Some time ago. I don't like using notes, really, but I was told that there'd be a lot of lawyers here. I'm going to be talking about lawyers. So let's get it out of the way. Here's a question I've heard once or twice. Have you seen the new Conspirator movie? Yeah. Okay. Yeah, I get that every 5 minutes or so. I'm very glad that that this case is brought into the public consciousness, you know, in terms of the trial and all of that. And as I said at Ford's Theater a few months ago, it's not really about the factual data and getting everything just right. It's really about bringing up a moral dilemma, bringing up some point of ethical concern. And let's face it, we all know that Redford did this because this kind of issue is back in the news and has been for the last 10 years or so. The issue of using military commissions to try, ostensibly, civilians. It is a very twisted question. Actually, the more you get into it, the more you find that it's not all that answerable. There are good points to be made on all sides, and I think that the best we can do is hope that people are learning from experience and going back to specific cases that have already come and gone, like the conspiracy, and taking from that the lessons about what really works, what's fair, what's not fair, and so on, and helping sort of refine that kind of system if we intend to continue using it now and into the future. I think one of the worst things we can do is ignore what the likely judgment of history would be if we were to repeat past mistakes. I think you probably all know enough about the assassination, and if you don't, I can recommend a good book. So I'll kind of gloss over that. It, of course, involved a conspiracy. There was never any question about that because of two separate attacks in different parts of town at roughly the same time. And you can all recall, you know, at September 11th, when we heard the one plane had gone into the tower. Oh my gosh, what a terrible accident. Second plane has gone into the other tower. No question at this point. It's over. No debate. It's a conspiracy. And that was the sensation that people had on the night of April 14th, 1865 as well. One of the other parallels, of course, is that the matter was resolved through the use of military commissions. And this is revived. It's fairly unusual in the great span of history that people would be put on trial this way, but it was fairly common during the Civil War. And I guess to the government it was probably considered a no-brainer. On the morning of April 15th, they probably said, well, no question about it, this is the way we're going. As they began rounding up suspects after the assassination, they found themselves by April 20th with about 300 or so, but still John Wilkes Booth had not been caught. John Surratt had not been caught. And a number of people they were looking for specifically had not been caught, in spite of an enormous dragnet. People were out everywhere, looking under every table, in every closet. Just unimaginable effort went into finding John Wilkes Booth and bringing him to justice. So on the 20th of April, less than a week after the shooting, Edwin Stanton put out a proclamation in which he said that anybody who's caught helping Booth would be treated as a conspirator, and there's a reward of $50,000 for anyone who helps us catch him or kill him. Actually, they didn't say it, but it's dead or alive. It's always dead or alive, no matter what you've heard. And you better believe that the number or the rate of captures went up dramatically on April 20th. And this would play a large role in the trial. It would play a large role in the perception of history, because so many people jumped into things believing that they would be entitled to some of that reward money if they helped put away some of these people who were involved. And I think you can see that coming through in the whole process, where people are saying, well, gee, I was in the Army at the time, I think I should get some of that reward money. They really had a very expansive definition of what constitutes bringing the conspirators to justice. Well, at any rate, President Johnson ordered the use of a military commission. Those commissions had been pretty controversial. They had been used pretty much throughout the war. The supporters said it was all because of military necessity. The opponents said that these are basically kangaroo courts. Whatever side you come down on, bless you. One thing is certain: these courts operated on the laws of war, not the articles of war as courts-martial had operated. The articles of war came down from congressional statutes going back to 1806, in which they laid out specifically, these are crimes, these are what you do and don't do, and that sort of thing. And any military attorney or person representing a military person could point to something and say, this is what my client is accused of violating. Now, it was a real weird experience for some of these attorneys in the conspiracy trial and in earlier military commissions as well, because this was a very subjective process now. They couldn't point to a statute. The laws of war were basically the unwritten code of conduct that generally nations observe and adhere to when engaged in war. And one other thing you can always say about it is that this came down through the executive branch, not the judicial branch, which administers and runs the court system, and not the Congress, which says these are the statutes. But the executive branch could take over as a matter of course. They ran the whole show. Congress tried to jump in the act, of course, and they passed a number of laws here and there. One of the things that they passed, and personally I believe one of the most important dates of the Civil War, then again it's just my perspective on it, is March 3rd, 1863, when the Congress stayed in session all night. The Sergeant at Arms went up and actually stopped the clock, because if it reached midnight it would be the next day, and they wanted to keep on passing other laws as some of their members on the opposition faded away, passed out, or whatever they did. But at any rate, one of the laws that went through was the Habeas Corpus Act, and one of the provisions of that act said that if the government, the executive, the army, and so on, had detained or held anybody, we're hearing a lot about detainees these days, well, they were detainees back then, if those people are thought to have violated a law that is tied to a specific statute, you must turn them over to the civilian courts where they are operating. Well, it didn't happen very much. One of the reasons was that the government was pretty determined to keep these cases, because the only people who could testify against these defendants in a court would be their friends and their fellow conspirators or their fellow rebels or their fellow traitors or whatever. You're obviously never going to get a conviction on cases like such as those they were involved in, the people they were detaining. They had created during the war, or I should say they resurrected the Bureau of Military Justice, and in 1864 Joseph Holt was appointed to be the Judge Advocate General and put in charge of the Bureau of Military Justice, and he was the one overseeing these trials. In time they really did sort of tweak the system and get it into a much better shape than it had been earlier. And one of the things that so many people were concerned about was the review process. When ex-Congressman Clement Vallandigham was arrested for giving a subversive speech, and he was prosecuted by military commission, the Supreme Court of the United States said that we can't review these cases like this because that's not a real court. And what that meant in essence was that if you wanted to appeal anything that came out of a military commission, you could only go to the president, because that's the executive branch. That's the avenue of authority, that channel of authority, which put a lot of hands in the power of an elected official, and that just made the whole process even more controversial. But that's what the law was in 1865. And everybody in the conspiracy trial, everybody involved in it, was very well aware that this probably would not get into the court system, although they were obligated legally to try by asking for writs of habeas corpus and all of that business. But at the same time, those judges who were going to be looking at this were also throwing up their hands and saying, what would be the point? That's another specter that hung over this entire process of the Lincoln conspiracy trial. Of course, John Wilkes Booth was killed, so he was not on trial. John Surratt was not caught yet. He was not on trial, but they whittled down that list of defendants, or possible defendants, to 8. And in general, all of them were charged as conspirators in the projected assassination of Abraham Lincoln, Vice President Andrew Johnson, Secretary of State William Seward, and General Ulysses Grant. There were some variations. Lewis Powell, for example, was charged with attacking Secretary of State Seward, and I wish I had the time to read the charges and specifications, because to a non-lawyer this is hilarious. And then with knife in said right hand of said defendant or whatever, he did strike and attack the said victim, cutting the said victim on said right cheek, etc. Sam Arnold was charged with the conspiracy, but also with counseling, abetting, and supporting, because he wasn't even in town at the time. Michael Laughlin and George Atzerodt were both charged with lying in wait for their intended victims. Mary Surratt with concealing, entertaining, and harboring. I like entertaining. I could do something with that. Mudd, Dr. Samuel Mudd with advising, encouraging, receiving, and harboring. And Edmund Spangler, stagehand at Ford's Theater, with aiding in Booth's escape by making sure that the path would be blocked by that wooden bar that shut the door leading back to the president's box. Well, all of these came under this big umbrella charge of they were incited and encouraged by Jefferson Davis and the members of his Confederate government, and all were done with knowledge, full knowledge of the whole aim of this conspiracy, except Edmund Spangler. Now, the interesting thing is that if you boil all these things down into the kind of charges that a civilian court would have tried, you'd see that in those days, many of these charges were actually misdemeanors. However, by just being a little bit creative in the wording, they pulled these cases away from the statute books, thus giving themselves the right to try them by military commission. Otherwise, Congress says you got to turn them over to the civilian courts. And that was one of the little things that the government had been doing for the last few years, 2 years, and they did in this case as well. That caused one of the defense attorneys, Walter Cox, to complain that it seemed like they were being charged with a little bit of everything. For example, if you were to steal a percussion cap with the aim of using it, did you get that little pun? With the aim of using it against the government, it's not just larceny, it's traitorous larceny, which they claim is a different thing altogether. Well, these legal irregularities were coming up right away. All military commissions made their own rules. And when Judge Advocate General Holt got together for the first time with the 9 officers appointed to this commission, they met in secret, and Holt started recommending the different rules he hoped that they would adopt. Holt recommended, for example, that when it came to summations, the defense attorneys should be allowed no more than 5 minutes. Keep in mind the prosecutor, John Bingham, took 2 full days eventually. Well, the commission didn't go for that one bit. And as a matter of fact, Cyrus Comstock was so adamantly opposed to this, and by the way, to the whole process, that he was replaced before the next day. He and Horace Porter had been on General Grant's staff, and the word came out that, well, because General Grant is one of the intended victims, we think it's a conflict of interest. They did, however, go with General Holt's recommendation to do the whole thing in secret, and Cyrus Comstock had a hand in dismantling that as well, because he did work for General Grant, and when Grant himself testified at the conspiracy trial as a witness, Comstock met him at the door, and they were walking back somewhere, and he said, they're not publishing this anywhere, it's all secret. And Grant said, well, that's nonsense, or something to that effect. And he went over to Stanton and said, they're doing all this in secret, that's nonsense. And Stanton had the whole thing opened up then to the press. But one thing they did, though, which military commissions didn't always do, is they did allow defense counsel to be something more than spectators. And I mean literally, they would say in the past, you are a spectator, be quiet. Now, in this case, they allowed defense counsel. They encouraged the defendants to get lawyers. And when some of the lawyers, some of the requested lawyers said no way, they went to the attorneys who had been engaged and said, do you mind taking on another client? And so that's how they ended up with everybody being covered by one. But that was not necessarily the law at the time. You did not have to provide an attorney if you couldn't afford one, none of that stuff. Well, Mary Surratt ended up with a couple of neophytes, and Senator Reverdy Johnson came in, and, well, you've seen the movie. But this legal maneuvering is what fascinates me, because if you read the transcript, verbatim transcripts, you find that the Confederate government was really more on trial than any of the individual defendants there in the dock. They kept taking testimony right away about the burning of cities, the sinking of steamboats, and other terrorist acts with which none of the defendants had actually specifically been charged. Now, these attorneys, some of them completely overworked, having no clerks or anything else, they felt somewhat compelled to start answering some of this, and they were told, this doesn't involve your client, so just sit down. So roughly 1/4 of the entire trial was devoted to issues and charges that none of the defense attorneys could answer, and probably they didn't want to anyway. They thought this was a side issue, but to Joseph Holt it was actually the whole point, because he and John Bingham, to a lesser extent Henry Burnett, the prosecutors argued that the assassination was just a natural outgrowth from the kind of government and the kind of war that the Confederates had been waging all this time and apparently intended to continue waging. What that meant is that these are terrorists and they're still dangerous. And that escalated things, of course, emotionally. Bingham even argued in front of the commission that he felt the conspiracy consisted of everyone who participated in the war on the southern side and all of their sympathizers. So they could be convicted just because they're pro-Southern under Bingham's argument. Not all the arguments made in this trial actually had an answer. The commission didn't say we overrule or whatever. A lot of these things actually just sort of passed as comments, and they just kind of moved on. Well, Joseph Holt technically was the advisor to the commission, the legal advisor to the commission, and there were a lot of these things that came up that Holt argued in favor of a certain application to the rules. There were lots of legal rules that seem very strange to us today, and I'll talk about those in a minute, but when Holt said, no, this is what it means, the commission, being 7 non-lawyers and 2 lawyers, pretty much took his word for it in more cases than not. Now, I'm not a big believer in, tallying up, well, they upheld this many of theirs and they upheld this many of theirs and saying, it's way out of balance, because you have to look at individual judgments there and see whether it really made sense. Some of those objections really deserve to be overruled. You know what I mean? That wasn't in the movie. One of those rules is that the defense cannot bring up any new matter. They can only respond to the charges. And when Holt got a hold of this, he said they can only respond to the formal charges. And so what happened, you can see how this works against the defendants. Edmund Spangler, for example, the stagehand at Ford's Theater, he listened to this testimony by Sam Chester about how John Wilkes Booth said he needed to find somebody who worked in the theater who could help them clear the path for Booth's escape. This was in a kidnap plot, but nevertheless, clearing the path for Booth's escape is exactly what they were charging against Ned Spangler. And because this had been brought up and because Spangler worked in Ford's Theater, they thought, aha, we need to answer that. And they brought somebody else in to testify that John Wilkes Booth had also been scoping out Grover's Theater, because he didn't care where he did this, as he was going to get Lincoln no matter where he showed up. But this was stricken because, as the prosecutors argued, we didn't charge Spangler with helping John Wilkes Booth prepare for Booth's escape in Grover's Theater. So he was being extremely literal about that rule. And that testimony was disallowed. Now, you and I would think, oh, okay, well, I mean, that makes sense that he would say, well, he didn't need somebody in just this theater, he needed somebody everywhere. But that wasn't allowed. In the case of Dr. Mudd, as a matter of fact, he was charged with helping Booth in his escape by concealing the fact that he was at Mudd's house and all of that. And testimony was brought to show that Dr. Mudd did not report John Wilkes Booth's presence at his house. Even on Tuesday when detectives came to his house and said, "Was Booth here?" He says, "No, I don't know what you're talking about." What Dr. Mudd's attorney, again, Thomas Ewing, tried to show was that, in fact, those people wouldn't have been at Mudd's house in the first place if he hadn't reported it, and the government people ignored it for 2 days. But when the prosecutors got in on this, they said, no, no, no. Dr. Mudd was charged with aiding in Booth's escape, judging by what he did on Saturday while Booth was at his house. You can't introduce what he did Sunday because that's not in the charge. And so you can see again how this rule, when interpreted very, very narrowly, ended up working against the defendants. This all kind of was related very much to the rule against defendant declarations, which meant that you can only use a defendant's words against him. You know the Miranda warning, anything you say can and will be used against you, not for you. And that was very literal in those days all over the place. You can't use your own words in your own defense because you're the one who just made that up. Okay? Well, this kept out a lot of testimony. For example, a man named Eaton Horner testified that he had arrested Samuel Arnold in Fortress Monroe, and that Arnold told him a lot of things about the conspiracy. And one of the things Arnold told him seemed to incriminate Dr. Mudd. Well, one thing that did not get into the court record was that Horner was writing down everything verbatim. And it didn't say anything like that. Nothing of the kind. But because it was actually the words of Sam Arnold, it could not be brought in his defense. And because also there was one other rule, very common in its day, discovery laws. Nowadays, in some jurisdictions, you have the right to know exactly what they've got on you. And you can even dig into all their investigative papers and all of that, which in this case would have included the statement of Sam Arnold. However, in those days, discovery laws were basically unheard of. And so when you keep out the actual words that Sam Arnold said were transcribed right away, and instead allow somebody, some third party, to tell you basically what was in it, what you're really doing is preferring hearsay. Am I right? Okay, because hearsay is, okay, he told me this, and I'm telling you.
The notes are also hearsay.
Pardon?
The notes are also hearsay.
The notes are also hearsay. But Sam Arnold said, this is what Sam Arnold says. Boom, and he signed it himself. And he said, here's my statement. That was not allowed in. But that secondhand account of that statement was allowed in. And so that also worked as well against the defense. Well, anyway, because the discovery laws were non-existent, and this was universal at the time, you really couldn't prove that somebody was wrong, even though you're like the kid in class who knows the answer and nobody will call on you. You know, you keep your hand up, and you know you can answer this. You know you can respond, but they won't let you. That combined with the promise of reward money kind of led to a lot of people. I don't want you to think I'm just picking on the government in this case, but a full, open, and honest discussion of what actually happened is what this is all about. And there were a lot of people, not all discovered at the time, who were, frankly, going into court and just lying on the witness stand. There was a man named William Ball, for example, because he was testifying about conditions against prisoners of war at Andersonville. none of the defense attorneys really, they couldn't question him, they couldn't, I mean, it wasn't any of their business. None of the defendants were, you know, Henry Wirtz. And so William Ball said that he had spent so many months in Andersonville, and he had personally been aware of the exact death toll up until March 24th when he left the place, and at that time there were 16,725 men who died there. And the highest toll for a specific day was September 9th, 1864. Well, there really is a very good accounting of the dead at Andersonville, and it was actually in what was it, October 27th. Had more than twice, almost twice as many people as the number who died September 9th, and the total official death toll in Andersonville was 13,171. Now, nobody could ask Mr. Ball where he got his numbers. He said he got them straight out of the books, but they're purely fictitious. And because this conspiracy trial is not really thought of as a trial against Wirtz, I mean, there's plenty of a record on that too in a separate trial. Andersonville researchers don't generally delve into this particular case. And when I started kind of rattling some cages some years back in the 90s, everybody just drew a blank. They never heard of William Ball. They looked in the records. There was nobody by that name who survived Andersonville. But this went unchallenged in 1865, and it helped feed that image of the Confederate government being so brutal, and the assassination of Lincoln just being part and parcel of their whole approach to things. There was a man named William Evans who just rambled on so much trying to put together all these different conspirators in one place, Mary Surratt's boarding house, that even the prosecutors just kind of said, oh, just sit down. And when the records came out in published form, they just said, and the witness went on in a very discursive manner, and et cetera, and just kind of got rid of him that way. But he was the man responsible, although I don't think anybody doubted he was just making this up. He was the man responsible for that story about Mary Surratt's house being the place where they all met. And it was perjury. They didn't all meet there. Not to say she was guilty or innocent or any of that. It's a different question. But at any rate, there were so many people in this trial who had questionable histories, and when you dig into their later history, you find out it was just horrifying where they got these people, and Joseph Holt was not at all careful about vetting them and their stories. They generally said after the fact that I walked into Holt's office and was on the stand in an hour or two. And some of their stories were pure nonsense. This is one of the things that can happen if you're not careful, if you don't provide witness lists, if you don't give ample warning to the other side. The most spectacular case of perjury, of course, was a man calling himself Sanford Conover. Rather than go into all of that, I think many of you probably already have heard the name. He was really Charles Dunham, and he had coached witnesses in this case, was later convicted and sentenced to 3 years in prison. Although he was telling the same story, but he was brought in to tell it before a congressional committee, and that's what he was convicted for. But that all fell apart. Anyway, the moral of the story in this case, because Holt really betrayed his interest in what his interest really was in here, that he was after the big picture. He was going after Jefferson Davis. That was his real focus. And that became clear when Sanford Conover, really Charles Dunham, had been exposed in the press. The trial was still going on, and the defense attorneys were starting their summations. They completed their summations, and then Holt went back and started calling more witnesses to do some damage control in the case of Conover and his witnesses. He called a whole series of witnesses, after the defense thought the trial was over. But in doing that, I think Holt revealed that really these guys, they're small potatoes. This is what we're really after. And the lesson of that, of course, is this was, well, let's say that a political use of the trial, the process, and whether that perception is right or wrong, the perception will always exist when you go outside the usual channels, when you go into secret sessions, when you don't allow full access to an open system, when you do all the things that were done back in 1865 and that were proposed again in 2001, you have to be ready for some harsh judgments from history. And in the case of the conspiracy trial, there was a backfire, absolutely backlash. That Holt's strategy may have been a bit short-sighted because it called his integrity into question, and he saw Charles Dunham exposed and his testimony go down in flames, and with it the public perception of Jefferson Davis as a monster and a conspirator. Davis was never put on trial because of the difficulty in finding anybody who was going to believe what Joseph Holt was going to bring to the stand after all of this. So it really was counterproductive for the government at that time. Now, again, in his defense, I don't want you to think I'm just picking on Joseph Holt. Defendant declarations, all these rules, they really were in place all over the country at that time, and nobody, even on the defense, would bat an eyelash at the idea of not allowing their clients to talk on the witness stand. Most attorneys don't want their clients talking anyway. But that was the system at the time. And of course, because the president in those days was the only one who could review those decisions and those verdicts, that whole process was again kept within the executive branch. And all of this started to unravel when the executive, Andrew Johnson, started having plenty of his political trouble as well. Now, it would be a long time before another high-profile case. They continued to use these commissions up through about 1870 or so, and it'd be a long time before they tried it again. It was not until 1942 Franklin Roosevelt decided that the hard-fisted approach was the best approach in the case of the German saboteurs. They were put on trial by military commission, and he insisted the whole thing be secret, and he also insisted that he alone could review the sentences of these people. Now, the convictions, of course, came along pretty swiftly, but then the Supreme Court stepped in a very rushed decision and approved the process in this case, something which some of them were to regret later. But that was 1942. That was a very famous case. Most people don't realize that a few years later there was another case of German saboteurs. There were two defendants, and this time it was handled a lot more quietly, and this time Roosevelt did not insist on, or the president rather, did not insist on being the only person to review the case. Judge Advocate General reviewed it as well, and this time they didn't get a whole lot of backlash really anywhere. In fact, I don't know of hardly anybody who's even heard of it. As a matter of fact, it is so obscure, I think, that when President Bush in 2001 issued an executive order saying that any members of Al-Qaeda would be tried by military commission, they went back to the 1942 decision, not the 1945 decision. And they said, okay, this is the way we're going to do it. They said, we're still going to have non-unanimous verdicts. We're still going to allow withholding of evidence from defense counsel. We're still going to reserve the right to use hearsay. We're still going to keep this strictly within the executive branch. But they did make some tweaks and some adjustments, and there was some legal wrangling for about 2 years. And some of these improvements included an appeal through a 4-person board, the first of which, by the way, many of you know, Frank Williams, was on that board. It was a 2-year appointment. And now the trials are, well, they're continuing at a snail's pace. But at any rate, they are continuing. And it's interesting to me that in all of these cases in this century, almost nothing was said by the executive branch, by the opponents, by the proponents about the Lincoln conspiracy trial of 1865. It was not deemed to be a suitable precedent. Now, I don't think we're all that good about drawing lessons from history, but at least in this case, there are many, many lessons to be learned, and I just hope we have enough sense that as we move forward, improvising systems and putting new things into place, that at least we can look back on a case such as this and decide for ourselves when something in history is worth taking a lesson from. Thank you.
Time for a few questions before.
I was just going to say, the first question is, how long is those parking?
3 hours. Any questions, comments? Sir.
The two German trials, 40s, the first I assume was all those who landed on the submarine and burned Long Island. I was not aware of the second one.
I was afraid. The question was the 2 German trials in World War II. The first one was the saboteurs, the 8 men who had landed in Long Island and Florida on submarines, got into civilian clothes, kind of worked their way in. That was the Quirin case. The reason I say I was afraid you were going to ask that because I forgot to write down the name of this case, which I didn't even hear of until recently, so I can't tell you much more about it. There is a book about military commissions by Louis Fisher, who works for the Congressional Research Service, and that's where I got the reference to this.
He has a very definite point of view, though.
Yeah, he does have a definite point of view, but my point is that there was another case that turns out to be very obscure, and that nobody has really gone to that case, and nobody has really gone. They have zeroed in on the Quirin case, the 8 saboteurs, because that seemed to fit, the present circumstances better than most others. But I'm sorry I can't give you a citation on it, but 1945, and it was 2 defendants this time. Yes.
The Kilpatrick Dahlgren raid on Richmond in 1864, where they found this note on Dahlgren that he was intending to kidnap Jefferson Davis and the whole cabinet, ransom them, and that Stanton was the one who ordered that directly. That's at least what Meade told Lee when Lee said, "What's going on? Why'd you do this?" And then they said Stanton kind of, during this trial, hushed everything up and kept it secret and had things destroyed because he didn't want to be blamed. And maybe this was a quid pro quo on the part of Booth. Was there anything like
Okay.
that?
The question for the recording was about the Kilpatrick Dahlgren raid in 1864. Early March 1864. It was broken up and Ulrich Dahlgren was killed. The question was whether or not any of this was orchestrated in order to sort of hush up Edwin Stanton's part in all of this. Well, a couple of points to be made. One is, as I look through the records, and I mean over many years, I really don't see as much of Edwin Stanton in all of this as I see Joseph Holt. And Stanton was very busy doing completely unrelated. He didn't even realize this was being held in secret the first day. He didn't order that. and people are seeing Stanton's hand in the use of the lily irons and the hoods and all of that business. And I really think that Stanton was kind of leaving a lot more of it up to Holt. He was there, certainly. He was guiding, helping write the charges and specifications and all of that. But I don't see him as being quite as big a player as some of the others do. The other point is that the Dahlgren raid was 13 months before the assassination, and people have tended to ask whether the assassination was in retaliation for the Dahlgren raid. And usually, if something is meant as a lesson, like that's because you did this, usually you say that at some point. And there's nothing even on the inside references that John Wilkes Booth said anything about the Dahlgren raid, and also that you usually don't wait that long to retaliate. Remember the case of the bombing in Beirut, 1983. Ronald Reagan wanted to retaliate, and by the time they figured out exactly who to retaliate against, they said, well, you know what, you have to do it quickly, otherwise the lesson is lost. And so they didn't do anything. So
Mosby's retaliatory execution in the prisoners of war is a good example. After his men treated as unlawful combatants, and he went
That's
up,
right.
He went up the chain of command to Secretary of War, said down in Richmond, got approval to do retaliation, and carried it out very quickly. And that pretty well ended.
That's right, John Mosby. And as a matter of fact, they specifically mentioned this is because you did that, and they did it quickly, and they got the approvals and had all the paperwork lined up, because they really, as in the case of the St. Albans raid, the Confederate government knew very well that all of these different, the articles of war and other things, they all made a distinction between somebody in uniform and somebody not in uniform. You're not protected if you're out of uniform, as those saboteurs in 1942 found out when they took their uniforms off. You're not considered to be acting in a legitimate capacity anymore. And so, to me, you put all of these different things together and you get a Confederate government that is trying very hard to play things more by the book. And I think that if they had done anything in retaliation or whatever, they would have cited that as their legal, we can do this because you did that. And they didn't. In fact, it just didn't come up at all until a long time later. So.
Another question? We're here. Yeah.
What was President Johnson doing during all of this?
The question is, what was President Johnson doing in all of this? He was president, after all. Johnson actually didn't even get just to give you an idea, I'm sure he was adjusting to the learning curve, having really not had access to Lincoln from Inauguration Day until the assassination. He had a lot to learn and had a lot to do, ramping the war effort down and everything else. But his hand did not seem to be all that much in this either. And he signed the order allowing the commission, or ordering the commission into existence, and then the modifications. He signed all of that, and then he also signed the order approving of the findings of the commission later on. But there's almost nothing in between the two that come from Andrew Johnson. John Wilkes Booth had written a little note and put it in his mailbox at the Kirkwood house saying, "Don't wish to disturb you. Are you at home?" And the next day they found this note, and people are going, "Oh, isn't that nice? You're a friend of the guy who just made you president." That would not come to haunt Johnson until later on, but it did come into the picture, and he was trying to be pretty low profile. Right.
Different because Truman was certainly on the scene immediately when Roosevelt died, and Johnson, you can imagine Johnson after Kennedy's death, he was in charge of finding.
Okay. Yeah, it's a good observation that that modern presidents jump right in and they get to be very high profile instantly, and Andrew Johnson was not. Well, one reason, without trying to get too philosophical, one big difference is news media. I mean, we had radio, television, and if there is an instant vacuum right there, and you have to calm down people's fears, and they're looking for news right now. In 1865, the news of the assassination didn't reach some people for a couple of weeks even, and so there wasn't quite so much of a vacuum to fill in. So maybe that's one of the many things that accounted for that difference.
The fact that, unlike the Truman reference, Johnson, although had been elected to the Senate, their vice president, came from a state that was part of the Confederacy.
That's right. Johnson was from a southern state, and that made his situation very awkward.
Lady in red, you had a question?
Yes, I have two questions. First question is, I'd like to know, had you looked at John Wilkes' diary, where the diary is, and did you read the diary? And the second question is, there was some talk about there being a $5,000 fund that was put up to assassinate the president, and it was put up by, I don't know if the Confederates did it or who did it, but there's been talk about that kind of situation, and they set it up a long time ago so that Wilkes would be financed.
Okay, I'll take the second one first. There was a rumor about money being raised to have Lincoln assassinated. During the conspiracy trial, they actually brought evidence against a man named George Washington Gale, who was a former federal judge, and he had put an ad in the Selma Dispatch in Alabama offering $1 million for anyone who would kill Lincoln. He said he was joking. $1 million Confederate, that would buy you lunch. Yeah. So, but at any rate, yeah, there were stories out there, and John Wilkes Booth's some of his own people were spreading the word around that this would be worth $30,000 for anybody. That was one of the things that they used to induce George Atzerodt, for example, to join the plot. Atzerodt thought he was just going to row somebody across the river and get $30,000 for it. Not a genius. At any rate, and by the way, in the balance sheet, he ended up lending them money. So anyway, but the other question is, did I read John Wilkes Booth's diary? The diary was very controversial. It was a little memorandum book that actors, and Booth was a famous star, and you go from one city to another as a star, and you write down, I've just made a deal with, Mr. Butch in Indianapolis. He's going to pay me this much. The first night I've said we're going to play Richard III, and I get 2 benefits in 2 weeks, and all of that. You're making your own deals when you go from place to place, and you have to keep it all down. Every actor, every star in that day had almost identical little memorandum books. This was the little pocket diary for 1864 that Booth had used previously, and those dates that actually had engagements in 64, those are the pages that were removed. Nothing all that suspicious there, sorry to say. But Booth had this with him when he was escaping. He was reading about all the nasty things people were saying about him. It's the first time in a long time he'd gotten bad reviews. And see, somebody's listening. And he sat down to write out his own justification for this. It was later said that Mary Surratt was framed and was innocent and all of that. And one of the things came out, why didn't, in this terribly unfair trial, why didn't Judge Holt allow this diary to be shown? Because, Booth practically said Mississippi didn't do it. No, he didn't. But the argument was that this would have exonerated people. This was part of that rule, that you can't introduce the words of one of the conspirators to exonerate himself or any of the other conspirators, because Booth was writing this after the fact, and he knew he was in trouble and wasn't in. Well, he could have said, "Oh, gee, it's too bad about poor Spangler. He didn't do a thing." maybe helping. So the diary was not admissible under any rules of evidence at that time to prove what was actually, to prove the truth of what was written in there. So that's why, you know, it was controversial, but it was a lot of hype. And it's in the National Park Service on display in Ford's Theater in the museum right now.
I think we have to, in light of the time, have to wrap things up at this point.
Oh, no way.
Mike, here's a small token of memento.
Well,
this
thank
evening.
you.
Thank you again.
It's
for
beautiful.
Excellent.
I love you.
Excellent,
Thank you very much.
see you all next time.
Thanks.